significant benefits to adjusting status. Most of my clients who want to adjust status are here. They don't want to have to go home to India or China or, Europe, for example, wherever they live, to attend a consular interview, which takes time and is obviously very disruptive if you work or study in the U.S. So you change your status here. You adjust your status from that underlying temporary status to green card. Okay, and essentially that's the process where one obtains your green card based on that underlying petition you filed if you leave here in the U.S. The EAD is an open work permit. So if you've had one before, the EAD, sometimes you'll have an EAD from OPT or STEM or some other, because you filed a different application. The EAD you'll get with adjustment of status is an open work permit, which means you can work for multiple employers, you can be self-employed, you can have part-time work, full-time work. It is open work authorization, okay? There are a multitude of benefits to having it, in the sense that you're not tied to your H employer, your L employer, right? So for a lot of my clients, that's incredibly beneficial. Once you have an EAD, you'll be able to get an SSN, Social Security number. Okay. Nowadays, it's traditional brick and mortar banking and other, loan operators. If you're looking for a mortgage loan, et cetera, they want an SSN. Advanced parole is it's essentially travel authorization. It's not a visa. What I always tell my clients, it's when you travel on advanced parole, you're requesting to be paroled back into the U.S., right? It's not, you're never 100% guaranteed to be admitted. Now, that being said, when you arrive at an airport and present advanced parole, you'll be put into secondary inspection, which is completely normal. It's because the officer has to make sure your adjustment of status is pending, okay? And so if you ever traveled using advanced parole, your attorney will walk you through what to typically expect and what documents to travel with, but, you shouldn't have an issue. It's not authorization to remain outside the U.S. for years and years. Okay, that's not what that's not what it, you could have the argument that would be misusing it. Okay, but it is travel authorization that is a specific benefit to having a pending adjustment of status to give someone flexibility to re-enter the U.S. if they don't have a valid visa or if their visa is expired. Okay, so for some of my clients that may have an expired H visa, L visa, if you've done visa stamping in India recently or a few other countries, it's taking a long time. It can be a pain. Sometimes your stamping can go awry for some reason. You can be put into admin processing, and they can delay your ability to return to the U.S. and work or see your family. And so advanced paroles, very beneficial in that sense if you are in that type of situation. And so at the end of the day, there's two things to think about. How old is your child before we file? Okay. What is the likelihood a wait list is coming? Okay. And how old is your child vis-a-vis, how long we think the wait list could be? If we can file now and we can do adjustment of status now, that's going to lock in your child for the remainder of the petition, okay, for the entire immigration process. So again, if we look back to our conversations about adjustment of status, the work permit, the travel permit, the most important aspect of all of this, of getting the adjustment of status in for a family that has a child that is in high school, I would say in high school at this point in time, or maybe in college, okay, is locking in their child if they're from China or from India, because both those categories will face a wait list in the future, okay? So again, if you can file adjustment of status concurrently with your I-526C, you're going to keep your child as part of that entire, immigration process, irregardless if there's a wait list in the future. Okay, that's another super important point. Yeah, I mean, I think it, like anything, any service provider, it definitely benefits you to work with someone who's done this before. There's lots of great EB-5 attorneys out there, and so I can vouch for many of them. I think it really helps make the process a little, much more seamless if you're working with a good attorney, if you're working with a good team that knows not only how to file a case, but knows what USCIS wants, right? Adjudication trends change, document requirements change, policy changes, and that can, significantly affect the case being prepared, whether, we're preparing something 5 years ago or now. Things change. Second, to your point, USCIS makes tons of mistakes. They, whether it's USCIS, Department of State, Department of Labor, all the agencies that are involved in the immigration process make lots of mistakes. They're busy, and some agencies are underfunded. There's a lot of policy that goes into this. I'm looking at this case status is unavailable. That happens for all my clients, right? IOE receipt numbers, I-526E and I-526 receipt numbers are very frequently unavailable for a variety of technical issues that the government websites is having. Doesn't mean your case has gone awry, just means the website doesn't work. Okay, and this issue comes up all the time. If your attorney has filed numerous cases, they're going to know this and they're going to be able to tell you what the issue is. Yeah, so it's a good point. Many attorneys who've done this a while knows that you often get predictive information from a previous month's visa or a current month's visa bulletin lets you know when a cutoff date is coming, and then you're very busy for the rest of the month because people want to file their adjustment of status when the priority date is current. So again, in your example, if you have you have a cutoff date in March that's published in February, right? You're going to need to file your concurrent I-526E and adjustment of status application in February, okay? Because again, your priority date is when you file that I-526. It's the day after you file, assuming you filed overnight, okay? And so if there's a cutoff date in March, you're going to be subject to it for the most part, okay? You need to get your adjustment of status in the month where the visa bulletin is current. So in your example, that would be February. Points to consider are the following, especially because, recently USCIS has mandated or essentially stated that medical exams shall be included. They need to be included with the adjustment of status filing, or else they may reject the adjustment of status filing. That wasn't always the case. You could file the adjustment of status and submit the medical exam later, or even wait till a request for evidence came. It doesn't always take a week to get these exams. There's vaccinations that are required. Some doctors' offices in certain cities, have longer wait times. And so, it's definitely something you want to consider. If you're going to do adjustment of status, you want to submit that medical exam. And again, if you file when it's current and your case gets rejected because there's a mistake in the form or you didn't include your medical exam, it's very unlikely that you're going to get to file when it's not current. You could try to you could try to plead your case and see if you could refile, but that case needs to be well prepared, and it needs to be acceptable, receivable when you file it.